Well, good evening, everyone. Thank you very much to Oliver for inviting me. I'm a lawyer at the law school. I specialise mainly in international trade, but with a particular interest in government contracts and the international regulation of government contracts. I'm really interested in defence procurement as distinct from the more sort of general procurement which relates to goods, works and general services. Before I discuss my topic, I should probably explain why I've chosen it. Well, I could have engaged a general debate on renegotiating terms of EU membership. That's quite topical at the moment. Generally, when we think about the EU, we think about economic sovereignty in the main. It's about the nation state. It's about, very recently, it's about fiscal centralisation, monetary centralisation. In the background, we have constant debates about social integration, social policy, common agricultural policies, all of these sorts of issues. But defence is actually rarely an issue that's considered in debates on the European Union. It seems to be one of those areas that we consistently think of as excluded from the scope of the European Union framework. Well, actually, I'm here to discuss today a very important aspect of European Union policy in relation to defence, and more specifically defence trade, and that relates to the field of defence procurement. Before I discuss defence procurement in slightly more detail, in particular an aspect of defence procurement that interests me, that relates to national security exceptions, I should probably give a brief overview of the history of defence and security competencies within the European Union. So, I'm quite interested in the concept of national security or essential security and how that's used as a means of competence for states to exercise power. So very often you might rely on national security grounds or emergency derogation grounds in human rights treaties to ensure that you can exclude certain provision or to place limitations on the exercise of certain rights or obligations in order to give a state a particular scope or discretion to act. In the field of defence trade, there's a very important provision under EU law that is Article 346 on the Treaty on the Functioning of the European Union. And that's a very broad national security derogation. It was initially adopted under the first European treaty, as it were. So to relativise this national security exception in its context, let's have a look at the history of defence and security competences within the European Union. So in 1950, René Pleven proposed this idea of what we called a European Defence Community Treaty. Now, the European Defence Community would have comprised supranational institutions, an EU budget, as it were, an EC budget, legislative competencies, a concept of a European army, so a form of centralisation of a European army supported by military competencies and an administration, a bureaucracy. This was an important idea in post-World War II context. It would subsequently transpire that the Soviet Union would pose a threat, an ostensible threat at least. And as a result, Europe considered this idea of a European defence capability, a single defence capability, that unified all four structures of the member states. However, at the time, there was a question about the primary significance to be attributed to defence. World War II was over. The question was whether or not we should turn towards an economic imperative within Europe, and that should be where we exercised our greatest strengths, so no longer in the realm of defence, but in creating a common market, internal market. So there was this idea of the European Defence Community Treaty, but with this background issue of Europe turning towards the economic imperative. What happened was the French Assemblée Nationale refused to ratify the proposal for the European Defence Community Treaty, and as a result, the idea of a centralised European defence community was put to bed. There have been successive attempts to try and revise it, not least in academia, although it hasn't had much success. There's been attempts at creating sort of battle group structures within Europe, within the European edifice, but none of them come true to fruition. So, by the end of the 1950s, we got a period of significant change. And in 1957, Europe moved towards more economic integration, originally through the ECSC, the EEC, and defence was really put on the back burner for a number of years. So was that the end of the matter? Was defence and security expressly ruled out of the EU's competencies for the next sort of 50 years? Well, the answer was no. In 1992, the Treaty on European Union introduced a common foreign and security policy. Then in 2001, the Treaty of Nice added the European security and defence policy, so bringing a more substantial defensive capability to a security policy. The most recent revision of the EU Treaty is the current consolidated version of the Treaty on European Union, one of two treaties which also comprises the Treaty on the Functioning of the European Union. Now, the current Treaty on European Union pursues a common foreign and security policy, and I quote, "It's committed to the framing of a common defence policy which, quotations, might lead to a common defence." The Treaty on European Union also makes specific provision for a common security and defence policy. However, the treaties confirm their progressive status, so to use the term in the treaty, it's very much an emphasis on progressive. We have a possible basis for an institutional framework, but no real policy supporting defence and security in terms of its enforcement. So, okay, that's a background to the history of defence and security competencies under the EU. In summary, they're very limited to the point of only really existing in theory as a superficial commitment that's never really been exercised. No European army, no substantial European defence policy with coordinated objectives. There's been just the odd peacekeeping mission here and there, but nothing substantial. So let's then look in a bit more detail at the relationship between defence and trade. The Treaty on the Functioning of the European Union contains provisions to ensure the free movement of goods, workers, services, capital and freedom of establishment. So for instance, if I want to sell goods to customers in France or Germany, they can't be subject to any binational laws. Similarly, British workers should be able to go abroad and work without relative restrictions on their ability to do so. Similarly, you can go and set up companies abroad without any national restrictions. However, importantly, the Treaty on the Functioning of the European Union has, in its various guises, also contained exceptions to the right to free movement on a number of grounds. An important set of these grounds are things like public policy, public security, although there's another very significant treaty exemption, and it's the one I've mentioned, Article 346 on the Treaty on the Functioning of the European Union. EU lawyers tend to differentiate this type of exception from the general exceptions I've just mentioned, those of public policy, public security. This is a very serious exception that's supposed to be very exceptional indeed. It doesn't just allow exemption from free movement rules, for instance, because if you exempt a measure from the application of free movement rules, it must nevertheless comply with the principles of the EU treaties, the overriding principles of things like non-discrimination and equal treatment. Article 346 is a different animal. Essentially, it allows an exception which permits derogation from the treaties in total. So, if you can successfully invoke this derogation, you can exempt a measure from the entire scope of application of EU law. So, it's very exceptional indeed. Well, the rest of my talk focuses on the wording of Article 346 TFEU. I give this idea of of whether or not, the question, I suppose, of whether or not Article 346 TFEU is the last bastion of national sovereignty for member states. I've already adverted to the fact that that's sort of a misnomer, in that the EU has already exercised defence and security competencies. So there is a limited extent to which the EU exercises its competences in this field. That's particularly true in the field of defence trade that I would want to discuss. But nevertheless, I'm interested in this idea of whether or not Article 346 TFEU may provide a residual legal basis on which to exempt particular measures from the EU treaties in a way that many are suggesting should no longer be possible. So if I just give a brief overview of the wording of the main part of Article 346 that I'd like to focus on. Article 346 provides that the provisions of the treaties shall not preclude the application of the following rules. Any member state may take such measures as it considers necessary for the protection of the essential interests of its security, which are connected with the production of or trade in arms, munitions, and war material. It's a very brief provision, but actually its content is relatively substantial. So, Article 346 TFEU, to reinforce it in its context, first appeared in Article 223 of the EEC Treaty, an earlier treaty, and reflected this clear preference to exclude all defence and security matters from supranational regulation. So we have this very important national security exception that was designed to ensure that defence and security matters were expressly excluded from the treaties. Importantly, this provision has never been amended. It's retained in substantially its identical form that it originally appeared 50 years ago. Now, the problem with a provision like Article 346 as an essential security interest derogation is that it's extremely broad. Where a measure is connected with the production of or trade in arms, munitions and war material, a member state may take any measures that it considers necessary, so we might think within its exclusive competence, for the protection of the essential interests of its security. Now, we can already guess why this provision might be significant in my field, the field of defence procurement. Since the 1970s, EU law has specifically regulated the public award of contracts. So, where a contracting authority in the UK awards a contract, it's required to open that contract up to European-wide competition in accordance with a set of specified procedures that are laid down by EU directives. Now, why must public contracts be open to EU-wide competition? Well, you can envisage the scenario in which there are large contracts available in a member state that could be opened up to other member states. So in the UK, contracts can be open to France, Germany, but you close those contracts off for national reasons. That might be to maintain your industrial base, it might be to protect jobs, it might be a dislike of other member states. Very often it can be simply anti-foreign sentiment. So you may seek to simply reserve contracts for national purposes. Well, the EU directives come into effect there to require these types of contracts to be opened up to EU-wide competition. So it's not possible for contracting authorities to legitimately discriminate against foreign bidders on contracts. However, this regime is substantially applied to civil procurement. So your supplies of office furniture, for instance, or services. There's a suggestion, an academic argument, that is probably borne out, actually, that this body of EU law, these EU directives on civil procurement, also have historically applied to defence procurement. However, for many years, member states have sought to rely on this essential security interest derogation under Article 346 TFEU to essentially exclude the award of all of their defence contracts from the scope of EU law. The suggestion was that maybe these contracts were regulated by the Public Sector Directive that operated in this field, So member states simply said, right, whether they are or aren't regulated by the public sector directive, will simply exclude these contracts anyway on national security grounds. So we've had a very successful, or relatively successful, development of an EU public procurement market that's regulated by very particular directives, public sector directive and a directive that regulates utilities procurement. But then we have an alternative market that's very fragmented. The defence market, because it hasn't been subject to these rules through the use of Article 346, is fragmented into 27 national defence markets. They're not regulated, they're highly protectionist, they're anti-competitive. In many instances, they may even protect obsolete industries. So it's very odd. We have a situation where we have essentially an internal market for civil goods that works, is competitive, functions, and then a defence market that is almost entirely non-competitive. The position has been exacerbated, possibly, or at least it's suggested, by a failure on the part of the Commission to exercise its enforcement powers properly in this area, and also possibly a reluctance on the part of the European Court of Justice to question member state recourse to Article 346 on national security grounds. Why? Because, well, the EU has very clear competencies to act in trade matters. It can intervene in the field of public procurement and also the field of defence procurement. But because procurement of defence contracts is so intimately linked with defence and security competencies and their exercise, there may have been, or that's the suggestion, a reluctance on the part of EU institutions to take a proactive stance in enforcing EU law in the area. So that's the background into how the EU public procurement market has developed in light of EU integration, the fact that defence and security competencies have largely been excluded, and how that's presented a particular difficulty for the EU institutions in enforcing public procurement rules where those relate to defence contracts. But the EU now faces a very difficult reality. The EU has to compete in a global market. The United States, for instance, has a strong defence market. The emerging economies, the BRIC economies, are developing capabilities, economic capabilities in the field of defence trade. As a result, there's a real fear that the European Union can't continue in the current state it is in terms of fragmented national defence markets that are competitive. There's a very real fear that the European market might become parasitic on the US market in terms that it might create a certain dependency on the US market for certain types of defence technology, certain types of defence material. So as a result, it's in Europe's interest to try and create a more coherent and cohesive European defence market. The way to do that is to institute a set of very particular defence procurement rules. In 2009, the EU introduced a specific defence and security procurement directive. The directive is essentially a modified form of the public sector directive that I introduced earlier on. It's designed to set out a set of procedures that must be followed by contracting authorities within the European Union when awarding public defence contracts. So these defence contracts now very clearly have to be awarded in competition, so they permit EU-wide competition, non-discrimination and equal treatment. There's a question as to whether or not it was actually necessary to adopt a specific instrument, but there's a consensus that in essence this was a policy decision by the European Union to make a very clear statement. The statement is this: look, member states, if you were in a position prior to the adoption of this directive where you considered that you could exclude all of your defence contracts from the scope of application of EU law, if you thought you could award them on a non-competitive basis and reserve them to national contractors, even though you were required to comply with EU law, you will no longer be permitted to do so. You must award your contracts in accordance with this directive. There is a specific directive that now regulates the field of defence procurement. You must comply with the rules. So the suggestion is that that will now operate to begin to liberalise the EU market and open up the EU market to EU-wide competition so that national markets are no longer protectionist. But there's one important qualification to the regime that's instituted by the directive, and that is that it remains subject to Article 346 on the Treaty of the Functioning of the European Union. So, for those that aren't EU lawyers, in the EU legal hierarchy, as it were, we have a set of primary provisions under the EU treaties, which are treaty articles. The EU can then adopt what we call secondary legislation, which are things like regulations and directives, which are intended to sort of implement the general principles that are introduced by the treaties. Now, these directives, as a matter of law, cannot essentially remove or delete or amend any provisions of the EU treaties. Why? Because they're lower in the EU legal order. So it's not for a directive to make any pronouncement as to the state of operation of, for instance, an article of the treaties. Therefore, the directive is essentially without prejudice to this national security derogation. So this creates a debate amongst EU lawyers and policymakers as to the continued role of Article 346. If you adopt a defence directive that's essentially designed to regulate defence contracts, the suggestion is that you should no longer be able to routinely invoke national security exceptions in protection of your national security interests. Why? Because there is no legitimate basis for you to invoke national security concerns. In essence, there was a suggestion that for many years, member states have relied on this Article 346 derogation simply to protect their national industries, that their industries weren't actually under threat, that there was no specific security interest that needed to be invoked, and that it was completely unnecessary to rely on Article 346. As a result, the EU institutes this measure and says, look, now these contracts are regulated by EU law. You don't have legitimate security reasons to invoke in these types of cases. Why? Because we live in the European Union, in which we have shared conceptions of security, shared conceptions of essential security interest. We collaborate on most, or at least many, defence projects. So why do you need to invoke your exclusive national security interests to reserve contracts to national companies? So that creates a massive dilemma, essentially. Many in industry think that Article 346 will continue to have a very prominent role. They think, well, even though we have this directive, we still have this major exception in the EU treaties that member states can invoke on essential security interest grounds to reserve contracts to national contractors. And that yes, we have a directive, but ultimately this provision will prevail. By contrast, we have a particularly robust stance by the Commission, for instance, that's keen to enforce these rules, saying Article 346 will now be very exceptional. It will only apply in very exceptional circumstances. And actually the European Commission, in a very rare move, prior to the adoption of the directive in 2006, adopted a specific communication on this provision, essentially confirming that this exceptional essential security interest provision must be strictly interpreted. It cannot be routinely invoked by member states. So my question then is, what continued role is there for Article 346? That actually requires us to look at a more sort of esoteric or conceptual level at what do we mean by the concept of an essential security interest. We have a series of cases dating back to the late 1990s, in particular 1999 in the case of Commission in Spain, in which we had member states trying, and that's been the case subsequently, member states trying to invoke this essential security interest derogation in order to exempt the imports of weapons from VAT, from tax. So, in the case of Commission in Spain, for instance, Spain imported weapons under the national territory. Under EU law, those were required to comply with VAT, so they were subject to VAT. Spain say, and this has been a tendency in recent enforcement cases as well, a member state will say, oh no, we shouldn't subject these to tax, we exempt these from the EU rules. Why? because it's in our essential security interest, our national security interest to do so. In essence, member states are using a essential security derogation to justify the non-payment of tax, completely contrary to the terms and aims of the provision. Now, the European Court of Justice, in a series of cases, has basically sent a very clear signal to member states and said, look, it is quite clear in these cases you're simply using and abusing the national security derogation for very, very poor reasons to not pay tax. And more importantly, member states, you're not providing very sufficient grounds for relying on essential security interests. What's very interesting is that in cases like Commission in Spain, a member state might say, well, we need to exempt these weapons from tax because otherwise it will render the weapons more expensive. That will have dire implications for our defence. It will impede our ability to operate within NATO. It will undermine the fundamental objectives of the European Union. All a load of rubbish. So the court has been very clear and said you can only rely on this essential security interest derogation of Article 246 in very limited circumstances. But unfortunately, the European Court of Justice hasn't engaged the language of the security derogation. So we simply have no real idea as to the circumstances in which it will be possible for a member state to legitimately invoke Article 346. What constitutes an essential security interest? What constitutes essential? What constitutes security? What constitutes an interest? To what extent do member states still have a competence to decide what is in their essential security interests? And conversely, to what extent can the European Court of Justice review a member state's decision to exercise that competence? Does the European Court of Justice stray into making judgments or determinations about which particular types of interest might be worthy of protection? All these sorts of questions haven't been addressed. Now, there has been some academic commentary suggesting that we should move towards a Europeanised conception of security interests. The general notion being that, well, because in Europe we all collaborate together on defence projects, because we all have a similar conception of security, because we're all in an area where an actual territory or a set of territories where we would, in essence, need to protect each other within the confines of NATO, we should move towards this European idea of essential security interests. The suggestion being that it's no longer a national concept, and that member states shouldn't be able to rely on Article 346 because, in essence, if we have a European concept of security, there are no real arguments to justify national decisions that rely on this exception. Now, I've taken a slightly different view to other academic commentators on what I think about this idea of Europeanisation. If this argument is made that we should move towards a European conception of essential security interests, my fundamental point is, shouldn't we have a serious informed debate, first of all, about what the traditional conception of essential security interests has been? Nobody's actually ever discussed this idea of what the concept of an essential security interest is. We can't have a new concept without knowing what the basis of the initial idea of an essential security interest is. More importantly, there's an argument to say, and this is why I had a historical discussion of security and defence competences at the outset, is it really the case that we all have shared conceptions within the European Union about what our security interests are? A prime example recently, the United Kingdom has concluded a bilateral defence trade cooperation treaty with the United States. It's a reflection of what is often termed the special relationship between the UK and the United States. What if somebody like the United Kingdom or another member state sees their common defence realised within NATO, and more specifically alongside America, see their common defence realised in a way that they don't consider the European Union or other member states to be able to provide? Well, in that instance, it's very difficult to make this argument about a unified notion of Europeanised essential security interests. So it's never been probed. I also have a specific example that I'm working on where I think there are a list of circumstances in which it's possible, I won't discuss it in any detail, where I think it's actually possible for a member state to continue to invoke its national security interests under Article 346. I think we're prepared to accept that, in essence, member states will no longer be able to simply say, look, I'm relying on this derogation to protect jobs, or I'm relying on this derogation to maintain my defence industrial base. So the suggestion is that you won't be able to invoke pure economic grounds, but I think there is a residual basis for member states to invoke it on security grounds, and my view is predicated on one very simple idea, and that is that security interests are interrelated and interdependent. So, for instance, if you were to say that a defence contract is to be sent out to tender, and you have French and German companies applying or submitting tenders for a UK contract, and a member state thinks, okay, well, we can award this contract in competition, but we want to reserve the award to a national contractor. Well, the reason is, why might it want to do so? Could it be for economic reasons? Possibly. Is there a legitimate security reason as to why it might want to reserve the contract to a national contractor under Article 346? My answer is possibly yes. What if you're in a situation where you feel that to award the contract to a French or German company, or a conglomerate of French and German companies, or companies from other member states, what if that poses a threat for your trade relations in relation to a state like America, for instance, the United States? So, for instance, say the United States is concerned about a European conglomerate developing, isn't particularly keen on this idea of French companies and German companies obtaining these contracts. The United States has a very close link with the UK and says, well, we might consider or reconsider the position if you keep awarding contracts to European conglomerates. They're in competition with American companies. Could we say we'll no longer award your UK companies contracts when you tender for contracts in America? Could we say that it might threaten a UK-US alliance if you were to keep awarding these sorts of contracts? This is all very remote, and there might be a legal argument to say, actually, because you have to provide a very specific justification for relying and invoking essential security interests, everything I'm talking about is a load of rubbish. But the point I'm generally making is that we can't rely exclusively on a national conception of essential security interests. You can't simply say, well, you can't reserve this award nationally anymore because it's in advance of your national security interests, and that's no good or shouldn't be defensible because we've got a European conception. The view is, my view is at least, that this idea of national security is no longer confined to a national conception of security, that a national security interest might be interdependent or interrelated with other interests. So our security interests might be affected by those of America, America's interests might affect ours, therefore we might be able to legitimately use security grounds in a much broader sense than perhaps might be suggested by newer interpretations of Article 346. So I think to say that we should have a European conception of essential security interests, which means we should no longer be able to rely on national security derogations, is too restrictive. And in a world of globalised trade and globalising legal regimes in the field of public procurement, there is a basis for revisiting our very basic understandings of what we mean by these national security concepts. So, to summarise, I think it's quite possible, contrary to the belief of some, that Article 346 as a national security derogation might continue to have a role, that derogations of this kind in other public procurement regimes may continue to have a role, and that these types of exclusions may continue to be the last bastions of sovereignty within the European Union. It's the last realm in which the European Union hasn't completely exercised its full power. It exercises its power in the field of trade. It's sought to leverage its trade competence to enter the realm of defence. But I think there's a possibility that member states will continue to adhere to this very clear conception of Article 346 as protecting their interests. The ingenuity of member states will be to try and see how they can define essential security interests to ensure the legitimate exclusion of contracts from the scope of EU law. Thank you very much.
Do you want to take questions?
Yes, please, feel free. Do you mind if I take a seat?
So I was thinking, it sounds like one of the major problems here is the kind of issue of understanding. So when you're talking about this kind of hierarchy of directives and such, like, would it be possible to create a kind of clarification that would supersede all of that?
Absolutely. One of the controversial proposals is actually, well, couldn't we better regulate the discretion that's exercised under Article 346 by, for instance, because we only have this provision that essentially says a member state can take a measure in relation to trade if it's in its essential security interests, but we don't have any definition. There's no legal definition of these terms. So the question is, could we have a list of permissible essential security interests? Could we have a clarification of the relationship between Article 346 and the directive, so that you've got a clear delimitation of how this applies in relation to the instrument? There have been all sorts of suggestions about actually amending this provision, deleting this provision. None have been successful. Most recently, a NATO industrial advisory group suggested that we provide legally acceptable interpretations of what Article 346 means. I have a number of objections to taking that approach. Not least, you better the discretion that member states might have. You might be overly prescriptive if you set out a set of legal prescriptions that say you can only rely on your essential security interest in this scenario. Further, I don't think we're at a state conceptually where we can definitely say what an essential security interest is. That's my basic problem with trying to regulate this exception or the use of the exception better. I make the counter-argument that actually, is it a problem with a conceptual uncertainty about what essential security interests are and how these exceptions should be used? Or is there a more fundamental uncertainty about the Commission's enforcement strategy and the European Court of Justice's determination about the appropriate bounds under which we should use or authorise use of this derogation? Because the Court has stayed very clear. It's veered away from considering the substance of what an essential security interest is. I think the Court is actually to be forgiven for doing so. The reason why it hasn't engaged the wording of the provision is because it's essentially said, look, whenever this has been invoked, it's for tax reasons. The reasons that you relied on aren't serious. Therefore, there's no need for us to give serious entertainment to the notion that you have a legitimate interest that needs protecting here, and that we need to make a clear pronouncement on in terms of whether or not we should legitimately protect it. So yes, I think there is a case for clarifying. The case has been made for clarifying the exception, but I've also made analogies with other areas. This is a problem faced across the world with international trade regimes. How do we appropriately define national security and security exemptions such that you can have a legitimate competence to exclude whatever you want to exclude? Under American law, there are all sorts of very broad exceptions that allow limitations on competition in contracts and exclusions from full competition. And nobody's ever really questioned the wording of these provisions or sought to seek very detailed justifications for their invocation. Similarly, under the World Trade Organization regime, there's a very similar exception that actually might even be broader than Article 346. Very little consideration is given to what is meant by its terms of use, by the legal sorts of definitions that we might give to the concept. And it's simply a very clear issue of, for member states, we like to keep these exceptions very broad, to rely on them. Legislators face the problem of defining these exceptions, but then there's ultimately a political trade-off in that process, and also there's a risk with over-legislating in an area that's designed to maximise discretion. The question then is whether the legislature should step in or whether it should be the courts as arbiters of the competence, essentially, of the European Union in this very sensitive field.
Excuse me, I was just wondering about the 346 is essentially a clause that allows defence companies to be out of the liberalisation of the...
well, member states, yeah.
Yeah.
It only applies to member states.
How does that work with the EU ban on arms exports to China, considering that essentially that the article was said that it's a national imperative about what you do with the defence industries? How does it...
Well, first of all, China is a third country under the EU regime. So you wouldn't need to invoke Article 346 in relation to a measure unless it's regulated under EU law and has incidental implications for or in relation to trade relations with a third country like China. The reality is actually that there aren't many implications of Article 346 in relation to exports to countries like China. It has only been tax cases. We've only got, I think it's 10, don't quote me, or 9 or 10 cases that are all tax cases. They're all enforcement cases where all we've had is imports of weapons from another member state and no tax has been paid on them. That's it. And member states have sought to come up with all sorts of arguments saying that, look, this will affect our trade reliance, our trade relations with other countries. It affects confidentiality agreements. I think one member state at one point tried to argue that it was in the furtherance of the objectives of the European Union to not pay tax on these weapons or to pay tax on movements of defence material, so as to sort of further some European defence and security capability. I mean, it's crazy. They're tax cases. And as a result, the courts have to treat them as tax cases. But there's not a lot on exports. A major issue that might become apparent, an issue I've not discussed in this presentation, actually concerns dual use regulation, which is much more significant in the field of internal and external movements of defence goods. That's a massive area that is so inordinately complex because you have essentially goods that are civil goods, but also with possible defence applications, and you've got all sorts of regimes applying there. I mean, there's a broader political question that I don't really need to go into with exports to places like China. It's a massive concern because the EU doesn't have the export into the legal infrastructure to really properly regulate this field. For a long time, there were EU codes of conduct on arms exports that the Americans have been very concerned about because all you're saying is, well, we'll provide relevant assurances that we won't re-export to third countries. But there have been reported problems, in particular with France and its relationship with exports to third countries that the Americans are worried about. So that whole third country regime, I'd love to talk about for hours. That's my particular interest. I look at the third country implications of the EU regimes, but it's a minefield. The question is, I suppose, whether Article 346 has a role in it. I don't know. Nobody's asked the question.
So would you say 346 has always been abused? It's never been used for national security reasons?
Well, commentators are actually very diplomatic in their approach and say many member states have abused Article 346. I've always defended the argument that actually I don't know whether it's been systematically abused by member states. Why? Because member states choose to invoke Article 346, and they may notify the Commission at some point, but there's no real policing of the use of Article 346. So that's one issue. We've only got a recent indication about the types of contracts that are actually excluded under Article 346 under what we call the European Defence Agency portal, which is a specific portal that applies to those contracts that have been excluded from the EU regime under Article 346. This is actually only a new development, and yes, there have been things like we are excluding this contract for fire helmets because it relates to to our national security interests. So we do have evidence to suggest that it has been susceptible to abuse and has been abused. This term abuse is used. There's not actually that much empirical evidence to substantiate the claim that it has been abused. Really, the problem has been a fundamental misunderstanding among member states, possibly about its terms of use. If you've got an essential security interest derogation and it says you can take measures that you consider necessary, all member states will think, well, we can legitimately exclude these contracts from the scope of EU law. And if EU public procurement law hasn't been very clear on whether or not contracts are regulated by EU law, and if the European Court of Justice hasn't provided very clear pronouncements about when you can rely on Article 346, it's not surprising that member states have used the security exception in a way that could be termed abuse. But the idea of abuse is actually an inference from the fact that the European defence market hasn't been developed. It's not empirically substantiated, at least not as far as I'm aware. There may be some research underway at the moment that has looked at it. We know in lots of shipyard cases that it's proven that it's being used in a particular way. But in terms of the general defence market, there's no indication as to how it's being used. It seems sort of like an ex post facto legal justification that's provided to explain why a European defence market has never been developed or fully developed. Whether or not that's exclusively attributable to Article 346, I'm not convinced. But it's nevertheless a substantial operating factor that's precluded the development of the market.